proper and smart estate planning is tailored. There's not one plan that will suit everyone.
It sounds like it can be simple, but it sounds like it can be really complicated. And the idea of the will is to try and mitigate as much of the complication as possible. It's a risk mitigation.
As your circumstances and your lifestyle change, your wishes may change.
If I'm dead, why do I care?
Estate planning isn't for you. It's for the people that you leave behind. It's your family, it's your children. And if you don't put proper measures in place or you don't make proper decisions now, it can lead to not only chaos, but it also can just leave like a very costly procedure because there may be disputes.
Don't be an asshole to the people you love. Hi everyone, welcome to another installment of the Investing for Doctors podcast. I'm your host, Dr. B, and today we have Tyrone Dutt here with us. So Tyrone is a partner at KHI Partners, and he's a solicitor, a lawyer who specializes in wills and estate planning. Welcome, Tyrone.
Pleasure to be here.
Before we start, this is going to be your first podcast with us.
Yes.
So why don't you give us a bit of an introduction about who you are, where you come from, and sort of your career as a lawyer.
Yeah, sure. So I'm a wills and estates planning solicitor. So I specialize in wills, powers of attorney, enduring guardianships, business succession. And I've got a particular interest in providing that to medical professionals. I've been a solicitor for 14 years now. Originally, I used to specialize in litigation. And it was through that, seeing all the disputes of contested estates and things like that, that I realized that if you provide proper and efficient planning, you can avoid those disputes. And that's essentially how I came into specializing in wills and estates planning. And I've done that for the last 6 years now.
Yeah, beautiful. And with, we're just going to go through some of the terminologies in the legal profession because it's another specialty. What's the difference between a lawyer and a solicitor?
Yeah, sure. Yeah. So a solicitor is a type of lawyer. So if you think about it in medical professional sense, a surgeon and a GP, they're both different types of doctors.
Yeah.
And so a solicitor and a barrister, they're just different types of lawyers. Yeah. And so a solicitor, if you want to liken it to a medical example, a solicitor is very similar to a GP. They'll diagnose the problem. They'll tell you, okay, here's the pain point. And a barrister is very similar to a surgeon in the sense that they specialize in one thing. So a barrister specializes in trial advocacy, just very similar like a surgeon may specialize in orthopedic surgery or So I guess solicitor is more getting the foundations right, the paper, all the legal contracts and that sort of, and the barrister is the guy that goes to court and fights that. Yeah, sure. Yeah. So like a solicitor can still attend court.
Yeah.
It's just that the barrister has a specialty in trial advocacy.
In trial, trial advocacy. That's the term.
Yeah.
And like medicine, there's lots of different sort of branches of law as well, right? So there's commercial law, there's conveyancing, there is wills, estates, there's obviously family law. That's another big one that a lot of doctors end up using, unfortunately.
Yeah, that's right. And so just like when you go and see a GP or any doctor, every doctor can't be across every area of law, every area of medicine. And just like, it's very similar with a lawyer. A lawyer can't be across, or a solicitor. A solicitor can't be across every single area, but there may be some areas that they specialize in.
And I guess when you said wills and estates, explain what is that?
Yeah, sure. So estate planning is probably an umbrella term in the sense that it encompasses the entire area of law, and your will is one portion or one piece of the puzzle for your estate planning.
Estate planning. Okay.
Right?
Yeah.
So your will deals with when you pass away and what your wishes would be when you pass away. A piece of the puzzle for estate planning is incapacity. And so planning for incapacity. So powers of attorney, enduring guardianships, etc. They help deal with issues where you're still alive. So it's very different to a will. So these documents plan for when you're still alive, but you don't have the mental capacity or what we call testamentary capacity to make decisions for yourself. And that may be financial decisions, it may be lifestyle decisions, it may be medical decisions. And so these documents allow you to appoint someone to make that decision for you whilst you are temporarily incapacitated.
Or permanently.
Or permanently.
Yeah.
Right?
Yeah.
And then the last piece of the puzzle also is superannuation. So not many people know that your will can't govern what happens to your superannuation because your superannuation actually falls outside of your estate. And so things like binding death benefit nominations and proper planning for, if you've got a self-managed super fund, making sure that, the trust deed is in place, making sure that it's all compliant. That's all encompasses in proper and smart estate planning.
Okay, all right. And with estate planning, is being the umbrella term, you have all these sort of bits and pieces in it, and that's sort of the main things you deal with when you say that you are.
Yeah, and I suppose proper and smart estate planning is tailored, right? There's not one plan that will suit everyone, and so. When clients come to me, we take a holistic view in respect of what their situation is, not just business, not just personal wise, but business wise as well.
Yeah.
What kind of structures do you have in place? Do you have any businesses that you own or invest in? When you invest, are you investing through different vehicles like trusts or companies, joint ventures, partnerships, etc.? And so every one of those little structures or vehicles that you're using needs a succession plan. So your personal side obviously needs a succession plan, but then your business needs a succession plan as well. What's going to happen to your business when you pass away or become incapacitated?
I think wills are quite sort of defining and straightforward. You're either dead or you're not. And so essentially a will is a set of instructions on what's going to happen to certain things that was in your control after you pass away. What sort of things are you, yes, we have our properties, we have, assets, we have businesses and those sort of things. They can get distributed to whoever that you want to, or they get sold or instruction for those. What other things are included in a will that's outside of the, the financial and the asset side?
Yeah, sure. So a will, a good way of thinking about it is will is sort of your playbook when you pass away, right? It's calling the shots of what should happen for different scenarios. And I thought that's why I was saying that, a proper estate planning should be tailored. Your will would be very different to what says in my will because we've got very different lifestyles. We've got very different...
and we could have exactly the same kinds of assets, but what we want happen will be completely different.
That's right. And the way that they're structured may be completely different, and where we want them to fall when we pass away are completely different. So your will is like your playbook, and it sort of says, when I pass away, this is what I would like to occur, right? But your will also does things like it nominates an executor in there, and that's the person that calls the shots. So if the will is the playbook, let's call the executor the coach. The coach comes out and says, okay, Tyrone or B has passed away. This is what we need to do now because this is what the will says, right? And one of the main jobs of an executor is to essentially audit the estate, say, okay, where are all the assets, right? Where are all the liabilities? Collate them all and then say, okay, what does the will say in respect of this property? What does the will say instead of this cash? What does the will say instead of this car, etc., right? And so the will allows you to essentially rule from the grave a little bit in the sense that it doesn't leave any uncertainty. Right? It provides the comfort that there's a plan in place and that I've prepared for this scenario. Rather than if you pass away without a will, which is what we call passing away intestate, the Succession Act in New South Wales, and there's a Succession Act in each state, that takes over. And that sort of says, well, this person has died without a will, and so we're going to give you an estate plan instead. Right? And this is what needs to occur.
So there's a default plan.
Yeah, that's right.
Okay.
But that default plan may not fall in line with what your wishes are.
And can I ask a slightly cynical question?
Yeah.
It's like, if I'm dead, why do I care?
That's sure. And look, that's an attitude that a lot of clients...
I'm sure a lot of people have that attitude.
A lot of clients come to me and say, well, don't worry about it. Like, I'm dead. It doesn't really matter to me. But estate planning, it's really important that you understand this. Estate planning isn't for you. It's for the people that you leave behind, right? And so it's your family, it's your children, but it's also your business partners that you leave behind, right? How does this now affect them? Your death, how does it affect them? And if you don't put proper measures in place or you don't make proper decisions now, it can lead to not only chaos, but it also can just leave like a very costly procedure because there may be disputes.
So I guess the
Mm.
If I were to market this, it'll be like, don't be an asshole to the people you love.
Yeah,
Get a will.
yeah. I suppose you could say it like that.
Yeah.
And look, everyone's circumstances are different, right? And so some clients come to me and say, look, I don't have anything in my name, so why would I need an estate plan, right? And I have a look through their structure and I say, okay, yeah, you know, everything seems to be in your wife's name, and you know, everything seems to be in companies and businesses. So, but I can see that you've got a pretty large superannuation here. Or I can see you've got a very large life policy here. What's going to happen with that when you pass away, right? Do we have a plan in place to ensure that this falls the way it's meant to fall, right? Let's do a little bit of a stress test here. Is there going to be a dispute when you pass away?
Just
right?
because it's easy doesn't mean it will end up being easy.
Correct, right? And so is there going to be a dispute when you pass away? And if there is going to be a dispute, is it going to be an expensive one, right?
It's going to rip your family apart.
That's right, right? And so I always tell people estate planning's part art, part science, because you can be methodical with it, but you also need to have the human aspect with it. So a great example of that is I had a client come to me the other day and said, I've got 3 children. My wife's passed away many years ago. I've got 3 children and I want those 3 children to be the executors of my will, right? Okay. And so thinking as a father, he said, I want it to be even with my kids. I want all 3 to be executors, right? But then, and scientifically and methodically, that makes sense. But when you go into the human side of things and say,
from an executive perspective,
that's right. You say,
tricky.
You think about things like, okay, do they all live in Australia, right? Because if you have an executor that lives overseas, there potentially may be a tax consequence for that.
You're right.
Right? Then you think about things like, do they all get along?
Yeah.
And are they going to be able to make a decision together?
Yeah.
Right. And if they're not, then I think you may have a problem here with the administration of your estate.
Yeah.
Right. And then you also think about not just about will they get along physically, can they make a decision together? Because if you've got people on all 4 corners of or all 3 sides of Australia, are they able to actually marry up their schedules to make a decision for you? Right. And is there going to be someone that's driving it more than the others? And so, like, I can go on and on and on about this, and that's just one decision
all the
of your will.
Yeah.
And so it's just about, essentially my job is I'm stress testing, right? And a client once called me a risk merchant. That's essentially what I do. I say, what is your appetite for risk? How much can you swallow? Right? And if you're a type of person that does not like risk, let's plan. Let's make sure that the plan falls in line with that. But if you have that attitude where it's like, oh, don't worry about it, it'll get fixed up and I don't really care what happens, right? And then we can tailor a estate plan for that as well. We can say, these are all your risks. And the client can say, well, I'm really comfortable with that risk. Fine. It's not for me to judge. It's not for me to impose a plan on you. It's for me to tailor a plan that suits and aligns with your estate, wishes. Essentially.
Yeah.
And your wishes. That's right.
Make that as watertight as possible.
Correct.
Yeah. So, it's good you raised that example of 3 kids. And so if you had 3 children and you didn't want to make it evenly, and you can do that, can't you?
In respect of appointing them as the executor or splitting your estate?
Splitting an estate.
Yeah, sure. Yeah. So the standard position is that you have to provide your issue, so your children, a provision in your estate, right? And the standard position is that that provision has to be equal. There are circumstances in where that provision cannot be equal. So for instance, if you've got one child that's younger than everyone else, that probably may need a little bit more financial support than the others. There may be circumstances where you've provided for an elder child, but not the other 2, and so you balance the estate essentially. Okay. Right. There may be circumstances where you've had a falling out. With one of your beneficiaries. So we're talking about kids now. So you may have had a falling out with one of your kids, right? And that can be an example of where you provide an imbalanced estate. It's very important that I say this. I can draft a will any which way you'd like. I can't guarantee that it won't get contested. All I can do is make sure that we put enough enough roadblocks in place, and we've done enough planning to ensure that your wishes are carried out. But sometimes when there's planning in place and it's just blatantly going to be contested, I just have a duty to tell the client and say, I think there's probably a bit of a high risk here that this is going to be contested. And then again, it just comes down to the client's appetite for risk. They say, I'm happy with that. I'm happy that, I understand that my kids will probably fight, but this is the way that I want it. And then it's just a matter for the client to make that decision.
Okay. All right. And I guess in the court of law, there is some benchmark that people apply, or is it they just fight until they come to a resolution, or well, what happens then? Because
so
you were a litigator previously.
Yes. So in that circumstance, if there was a child that felt that they should have received more, or that they didn't receive enough in a will, you can make what's called a family provision application, and that just essentially tells the court that you want to challenge the will. You want to say, well, I don't actually agree with what's going on here. And that can happen with a number of situations. So the situation that we're talking now in respect of a child saying, well, what about me? I should have gotten more, or this isn't fair. But it may also be someone that comes out of the woodwork completely and says, oh, well, before Uncle B passed away, he promised me that he would give me $100,000 to set up my medical practice. And unfortunately, he passed away the day after he told me that, and it wasn't recorded in his will. So I want to make a family provision application to make sure that I get that $100,000, right?
Yeah.
But there are a whole bunch of messes in court that can be litigated as well. So, for instance, clients say, oh, I want to give my nephew $100,000, right? But when they pass away, they don't have $100,000 in cash.
Yeah.
And so an asset may need to be liquidated in order to pay that cash, but that asset may be gifted to someone else.
Right. Yeah.
And then so there is a dispute there because, maybe a house needs to be sold, or a stock portfolio needs to be sold, but that stock portfolio has already been gifted to someone else. And so that person says, well, why does my asset need to be liquidated in order to ensure that you get paid what you're promised, right? And so this is what
I love the disaster cases.
And this is what proper planning avoids, right? And estate planning is living and breathing. There's this mindset that estate planning is set in stone.
No.
You draft it, you put it in it's like the 10 Commandments. It's carved into a tablet, you put it into your drawer and you forget about it, right? But estate planning is living and breathing, because as your circumstances and your lifestyle change, your wishes may change, right? You may have a falling out with someone throughout the year. You may not want that person to be your executor anymore. You may not want to give that gift to anyone, to that person anymore. And so you need to adjust your estate planning to reflect your wishes, right? And so I'm not saying that your estate planning needs to change every year, but you do definitely need to review it.
Yeah.
Right?
Oh, absolutely.
It just needs to be top of mind.
You might acquire things, right? And then you just go, okay, this property goes to someone else. Or you have a blanket provision that all my properties will get split or something, right? So it's the more complicated your life is, I guess, the more complicated the estate planning is going to be.
Well, yeah, and your estate planning is there to ensure that you cater towards the way that your assets are structured. So, but it's not just that; it's about your family, how your family is structured. So, your children may grow up and get married. You may want to have the view that your children should be the only people that enjoy your inheritance, and not your in-laws, right? And so if there was a marriage breakdown between your kids and their partner, you would want to make sure that your inheritance doesn't form part of those separation proceedings, right? And so there are certain mechanisms that you can put in your will to avoid that. Like one of them is, and I'm sure some of your listeners have heard of, is a testamentary trust. Testamentary trust ensures that the assets are protected, like we said. So it's protected from divorce proceedings, liquidation, bankruptcy, etc. But then also it allows you to have tax minimization, streaming mechanisms to allowing you to stream money out to minors. But then also the major thing with testamentary trust, which I love about it, is that it has a built-in family lineage mechanism, so that when you pass away, it goes on to your children. But then when they pass away, they can't gift it away. trust automatically flows down to your grandchildren and so forth.
So blood lineage, yeah.
Correct. I suppose I'm coming.
It's ruling from the grave, really.
Yeah, it is. It
it's
is.
more ruling from
it
the
is,
grave.
and allows you to have that control, right? And so I tell a lot of people that become a little bit hesitant because when you use that term controlling from the grave, they kind of a bit standoffish and they say, "Oh, that sounds like I'm becoming a little bit of a control freak." But if you think about it.
It's perpetual protection as well.
That's right. But the generation that have come through, so baby boomers and then onto Gen X and millennials, they've generated a large amount of wealth. And so the shift of wealth from baby boomers onto Gen X, millennials and Gen Y is the largest shift of wealth in history, right? But if you think about before that, the silent generation onto the baby boomers, they didn't really have much to gift over because they were either immigrants or they were post-war immigrants. And so they actually had nothing. And so this mindset that, don't worry about it, like, it all gets sorted. There's too much wealth accumulated in that generation to have that mindset anymore. And so you actually have something to gift.
Yeah.
You actually have something to protect. And you have the ability to create intergenerational wealth, right? Wealth that doesn't stop with you physically. It can pass on to not just your children, your grandchildren, your great-grandchildren. You can actually create a lineage. And that's what proper and smart estate planning does. It protects that.
And I guess, as you said, a lot of it came from the parents' generation, the generation before that, where your dad boy didn't have anything, and it didn't matter. But now it does matter.
Yeah, that's right. And so gone are the days of having that 3-page will. Yeah. Right. It doesn't provide enough protection. It doesn't plan for enough. Right. And the more ambiguity that you have in your estate plan, the more chances that you will have a dispute. Because there's more chance of people interpreting things differently or having to think about what you would have done. All right. So if your will is silent on something, they then have to guess and say, okay, what would B want to happen here? What would mum want to happen here? What would dad want to happen here? Right. But if you plan and you are able to provide a set of instructions that incorporate not just your personal holdings, but your business holdings as well, it shows that you've thought about it. It shows that you've given thought for it. And you're able to, if you update it and you constantly review it, it allows you to provide that protection for your family.
Yeah, beautiful. So I guess the way we look at this now is that it's a living document. You review it every many years, or upon a major change in your personal circumstances, such as maybe the divorce, separation, birth of a new child, or
purchasing a house, purchasing a business,
or assets and that sort of thing.
Yeah,
right?
all that stuff.
Yeah, so family changes, holding changes. Yeah, I guess we touched on this a little bit already. In the event that there is no will, can you sort of detail exactly what happens, just to give our listeners a bit of a idea of what you have to deal with?
Yeah, sure. So if you pass away without a will, you pass away what we call intestate. You die without a testamentary instrument, which is your will. So there's no instructions of what to do. When you pass away with a will, you apply for what we call probate. And you apply to the Supreme Court and you say, this is the last will of the deceased. It's got the executor in there. It's got all the set of instructions. I need you to rubber stamp it. So they essentially give a rubber stamp and they say, okay, you can administer the estate. We give the authority for this person to administer the estate.
Why the Supreme Court?
That's the governing body.
Okay.
Right?
Okay.
Supreme Court of New South Wales.
Yeah.
In New South Wales, obviously. But, if the majority of your assets were in Queensland, you would have to apply to Queensland, etc.
Okay. It's a majority thing and not so much like...
So it's generally where the majority of your assets lie, yes. And if you do have assets in other states, you would have to apply for what we call a reseal.
Oh, a what?
A reseal.
A reseal.
Yeah. So you obtain probate in, say, the majority of your assets are in Queensland. You obtain for probate in Queensland. But then if you do have properties in or assets in New South Wales and other states, you would just take that probate, that approved probate, and you would go to the Supreme Court in the jurisdiction that had the other assets, so say it's New South Wales, and you say, I've already got probate in Queensland, right? I just need you to give me a rubber stamp, a seal to deal with these assets now that are in your state, because every state has a different set of succession legislation.
Yes.
Most of them marry up, but some of them are very different.
Right. Okay. Now, trick question. What happens if you're stuff overseas?
So if you've got stuff overseas, that would be, and that's a really good question, actually. I advise clients for you to have a will in every jurisdiction that you have an asset in. So when I say jurisdiction, I loosely mean country. So in Australia, have an Australian will to deal with your Australian assets. You have assets in the UK, have a will drafted in the UK for your UK assets. The reason for that is, although you may have a will, say in Australia, that comments on, provides instruction for assets that may be in the UK, US, etc., South Africa, wherever it may be, those jurisdictions may not accept the will. They may say that, this will isn't binding in our jurisdiction, or it doesn't meet our compliance rules, or even if they're all Commonwealth countries, for instance, right? They may say, well, unfortunately, you haven't drafted a will that's compliant with our succession legislation. So they may say, I know you've got a will and I know it's Australian, but you've actually died intestate in UK. So they may have their own sets of rules for what happens when you pass away without a will. So
that sounds like a pain.
Well, it is. And it's a risk, right? And going back to the risk merchant thing, some clients say it'll sort itself out, right? But for those clients where I say, well, this is actually a large part of your jurisdiction,
assets,
assets, and your estate, but then also, there may be some tax liability here, right? Let's do some proper planning to ensure that you're minimizing the tax, you're protecting the asset, but then also you're making sure that the assets flow down within your bloodline.
Now, next part to that is that if those assets are being dealt with in a foreign jurisdiction, and if you had a testamentary trust, do you have to have similar instruments over there, or can it be folded in, or and what quantifies as an overseas asset? I think that's probably the better question to ask. I mean, a property, that's an overseas asset. But what about like shares in an overseas company? Is that considered say if I have a substantial holding, in a UK company? Where does that fall under? Is
it a private holding or is it a public
holding? For instance.
So if it's a private holding, I would say that it's an overseas asset.
Okay. And if it's a public holding?
If it's a public holding and it's on like a
stock exchange.
A stock exchange, then it would be dealt with just with the Australian Stock Exchange Registry, right? Okay. Because the Australian Stock Exchange Registry has allowed you to purchase, or has been the vehicle in order for you to invest and purchase.
Okay.
Right.
Okay. And if it was in some, other countries that, for instance, we didn't have a brokerage here and I got a local brokerage in that foreign country, that would be in the foreign country?
Yeah.
All right. That's very interesting.
I would, I've never had that before, but I would consider that to be a foreign asset.
Yeah. And I guess when you're a British common law country, the rules are similar or are they very different?
Look, there are tax treaties between Australia and look, we're really branching out here into tax law a little bit here. I should premise this is general advice. And
this is all general advice. It's just interesting to
but
explore that. Yeah,
sure. And so when you have assets that are overseas, right, there may be some tax implications for administering your estate in Australia and including that asset, right? So you were talking about testamentary trust and having a foreign asset come into that testamentary trust, chances are there probably will be a large tax ramification for that, right? But having proper planning in place and considering that now may alleviate that tax.
Some of that tax,
right? And so there are really great tax solicitors and they're really good accountants that specialize purely in this, right? Because it's such a massive area right now. Because overseas investment is becoming larger and larger, and it's becoming more accessible.
Right? And this is the thing. The world's globalized, populations are a lot more mobile now. I mean, a big chunk of the medical profession are immigrants.
Correct.
And they often hold assets overseas.
Yes, they
or
do.
in multiple jurisdictions.
Yes.
And I don't think a lot of people know what's going to happen with a lot of these things because we haven't got to the generation where, this really mobile generation starts dying off in large numbers yet.
That's right. And so when you have an Australian resident inheriting an asset that may be from China or India or the UK or US, you have to really think about it's not just as simple as someone just changing a name on a title.
Yes.
There will probably be some sort of tax ramification, not only just in Australia, but in the other country in respect of owning that property, right? Particularly if you are then considered a foreign resident in that country.
Yeah.
Right? You have no citizenship in that country. You don't spend any time in that country.
What happens?
That's right. There more than likely will be some sort of tax ramification. And again, that's where proper estate planning comes into all of this, where it says, okay, if this was to happen as of today, what would be the issue here?
Yeah.
Right? Is there a tax implication here? But it's not just so much about a tax implication, but if you inherit this property, are you now vulnerable? Right? Is this property or is this asset now vulnerable because you own it? The medical profession, very similar to the legal profession, right, is high risk, right? Because the duty that you have to patients, but because of that and the duty that you have and the high risk nature of your job, chances are that there's a larger risk of litigation when things go wrong.
It's okay. Yeah.
Right? Right. And solicitors are exactly the same, right?
Yeah.
But because of that, when you inherit something in your name personally, there's more risk for that, right? You have more risk of that asset being vulnerable to possibly being lost to pay for compensation.
Yeah, I mean, that's a really good point. I mean, look, in Australia, we have probably one of the best indemnity systems in the world. And I don't recall anyone that has lost their house practicing medicine unless, they were really, really dodgy. And then sometimes their personal liability comes into it. But a lot of doctors do other things outside of medicine. So that puts the risk there.
Well, that's right. Yeah. So it may be, a business venture that goes wrong.
Yeah.
So,
absolutely. Yeah. If you're a director of something.
So there may be director liability issues there, right? Yeah. And again, the corporate veil in Australia is pretty good. But, if it's proven that, you intentionally did the wrong thing, then
you're negligent.
That all that stuff comes at risk. And so it's about balancing it out. Right. So again, the scale of risk, what's the likelihood of that happening? Right. And then you measure it against a response of, do we need to plan for that?
Yeah.
Right. And then you measure that again against what's your appetite for that risk. So there's a high chance of that happening. We should probably prepare for that.
Yeah.
And your appetite for risk may be really high and say, I know there's a high risk of that, but I don't really want to plan for it. I'm just going to see how things fall.
Yeah.
And at the end of the day, my job is just to present the risk to you.
Yeah.
It's just to present, we can plan for this. We can avoid this risk.
Yeah. Yeah. You can lead the horse to water. Yeah.
Yeah, that's true. Yeah.
Can't force them to drink it.
Yeah.
Yeah, that's very fascinating. I mean, this is just talking about wills, right? And get back, we sidetracked a little bit. So when we die without a will. Yeah. And so
you have to apply for. We digress because I was talking about what the actual process is dying with a will.
You get the probate. So you get the stamp.
Yeah, that's right. So when you apply, because you get the stamp because the will will say, this is who I nominate as my executor, and this is who I nominate as my beneficiaries to my estate. Okay. Executor, this is who's controlling my estate. Beneficiaries, this is who's receiving my estate.
Yeah.
Right.
And is this a time-consuming process, or is this like you passed away, this is the will, hey, stamp, done, or do you have to queue up and get time?
Well, I suppose if I want to liken it to a procedure, it just depends on how many complications there are with the procedure. Same sort of thing with the application, how many complications there are. So, are there people looking to contest it? Are there is there issues in finding the assets, right? Is there issues in finding the beneficiaries, etc.? Yeah. So if there's no issues, then technically, no, there really shouldn't. It should be a pretty simple process, right? But as you probably know, like life doesn't always turn out the way that it's meant to, and so sometimes there can be some complications along the line. And the court can make what we call requisitions. They can say, "Oh, I really want to know a little bit more about this, and I really want to know a little bit more about that. Can you satisfy me on this?" right? And that can be a process. But generally speaking, yes, it should be a swift process.
Okay. If no complication, swift process.
Swift process.
Okay. Complication, then how long's a piece of string?
Yes,
kind of
that's
thing.
right.
Right. Okay.
So that is the probate process when you have a will.
And then it gets carried out according to the will.
And it is swift because you've got the nominations in place, right? When you die, what we call intestate, so there's no will, the court essentially says, okay, I've got to appoint someone now to take care of this estate, and I want to make sure that I'm appointing the right person, right? And so there's the Succession Act that essentially says that if you pass away without a will, everything goes to your spouse. If you don't have a spouse, everything will go to your children. If you have no children, everything will go to your parents. If you have no parents, brothers and sisters, and there's a line, right? There's a whole succession line.
What's the definition of a spouse in this situation?
Right, sure. So the spouse will probably the definition of spouse will come from the Family Law Act. And so it'll essentially say someone that you're married to or in a de facto relationship with. And again, we're going to just have a podcast just solely on that issue as well. But, the definition of what a de facto partner is can become a little bit complicated. But generally, it's someone that you've been in a relationship with 2 years or more. There can be some variances to that as well. Yeah. So,
I've seen situations where there's someone has one family in one place and another family in another place. I'm not justifying that.
Yeah, so this is where I was going to say we can have a whole podcast just on that, because sometimes a spouse or a wife may say, I'm applying for letters of administration.
Yeah.
Sorry, let's just take a little bit step back. When you apply without a will, it's called letters of administration.
Yeah.
So it's essentially a judge saying, I can't stamp a will, I can't give you probate, but I'm going to stamp this piece of paper, and I'm going to say, on this piece of paper, this is who's going to administer the will, right? And so there may be an application from a spouse, right? So the wife may make an application, but there may be a de facto partner that the wife never knew about. So there may be two people applying for who should be the administrator of the estate. So that can be an issue in itself. But generally, what should happen is whoever is first in line, so spouse, children, parents, etc., they make the application and they say, I'm applying for letters of administration, and this is how I'm going to divide the estate. And they should tell the court how they're
so they need to tell the court how they're going to divide it, and then the court will say, okay, that's reasonable, or no, you're completely biased and you should not be.
Correct. So it may be that, for instance, a brother or sister are making an application for letters of administration and they want to give the entire estate to themselves, but the parents of the deceased may still be alive. And so the probate register will say, I want to see the death certificate of the parents. Otherwise, the parents should be
included.
And who should be applying.
Oh,
right?
yeah.
Right?
Oh, as in a brother or sister of the deceased.
Yeah.
Yes.
So it can become quite complicated in that sense.
You got to prove that you're next in line.
That's right. And so that's why that process can be quite lengthy as well.
Yeah. And people appear out of the woodwork.
That's right. People appear out of the woodwork. People make applications to say that, I loaned B, $20,000 before he passed away and he never paid it back to me, etc. Or it might be the other way around, administrator may say, B loaned you $20,000 before he passed away and the estate wants to recoup that back.
Yeah.
Right? That's actually an asset for the estate. So it can become a little bit of a lengthy process when you're applying for letters of administration, but then like in a very similar circumstance to how we were talking about applying for probate, it can become a quite streamlined process as well. Yeah. If you've got the right people applying, and there are less complex structures, then you can just get letters of administration pretty easily, and it'll work exactly like a stamped will. It's just a piece of paper giving the authority for someone to administer the will. So then after that, you can get access to bank accounts, you can access to properties, directorships, etc.
It sounds like it can be simple, but it sounds like it can be really complicated. And the idea of the will is to try and mitigate as much of the complication as possible. And it's a risk mitigation sort of.
Yeah, I think that's a really good way to describe it. It is risk mitigation in the sense that if you're going to plan for something, one of two things happen. If you can plan for something, it obviously can avoid that risk. But then it also can show if there is a dispute that you've thought about it. All right. So if there is a dispute, the court is reluctant to change a will. All right. Particularly when someone has given thought to something.
Yeah. So if you're reasonable about it.
Yeah. So if there was an imbalance in the estate, so we were talking about 3 children earlier, and there was a reason stated that said, the reason why I am dividing my estate instead of a third to make it unequal is because I've provided enough for my my eldest, and I'm actually gifting them my business as well. So in my personal estate, I'm just ensuring that my younger 2 receive the larger lion's share. If the eldest wanted to contest that, which they're entitled to, if there was no reasoning whatsoever, or if there was no estate plan, or there was no will or anything like that, the judge is essentially flying blind because the judge is relying on the applicants to tell him or her the story. Right? Tell me what's going on here. Tell me what's wrong.
Yeah.
But if there is a will in place, there's a letter of wishes in place or something along those lines that explains what the decision is and why the decision is there, the judge can say, I understand that you are unhappy with this decision, but I can see that there's
it's reasonable and tough luck.
Yeah, and there's been some pretty careful thought here put in place here.
Okay, so you just have to adjust costs for a lot of things, I guess. Yeah. Then we've still got a lot of things to talk about estate planning. And I guess the next part of it is the superannuation, which is something that everyone has.
Yeah.
And you mentioned that superannuation operates outside of the estates sort of system. And I think a lot of us are aware that you got to put a binding death nomination on it.
Correct.
All right. And my understanding is that when you have that, there's really not much contest in that, as long as that's legally that's the right person to receive it. Yeah,
sure. So like I was saying earlier on, we can put a plan in place. I can't guarantee that no one will contest it, but I can just make sure that your wishes are protected as much as they are.
Yeah.
They can be in accordance with the law. So a binding death benefit nomination is essentially a direction to the super fund that says, when I pass away, this is what I would like done with my superannuation. The Superannuation Act and says that you can leave your superannuation to your family, right? It can be spouse, children, mum and dad, brothers and sisters, etc. But the ATO says that there may be a tax implication if you do not leave your superannuation to either your spouse or a dependent under the age of 25.
Oh, right. So it's a tax issue. It's not that you can't. It's just that.
Yeah, that's right. That's right. There is also an entitlement issue there as well. So if you decided to give all of your tax to your best friend, right? If you decide to give all of your superannuation to your best friend, chances are there will be a contest there. And there would also, your superannuation fund would also be questioning whether they are entitled to do that. So a binding death benefit nomination, again, just ensures that you've thought about it, but also provides that surety. So it binds your superannuation fund to go for it to go somewhere. Otherwise, what you essentially do is you leave it up to your superannuation fund. So,
but that forms the part of your estate then, doesn't it?
Well, you can pay it into your to your estate, or you can pay it directly to someone.
But if there wasn't, so if you had no binding death nomination, because you just didn't bother doing that, that would then go to your estate? Or?
Well, it's essentially up to the trustee of the superannuation fund.
Oh, really? Okay.
Yes. So they've got the discretion to do that. And so what may be the issue is that we're talking about 3 children, so let's use that example
the
again.
The usual problem.
So the trustee can say, well, I'm actually, I can give it to all 3 of you, or I've also got the discretion to just give it to one of you, right? And so there may be an application for the youngest, right? The youngest say that, well, I need it more. I was actually the most dependent. Right? You may also have an issue where one of them literally is still a dependent.
Yes.
So you may have a child that, is 27 and living out of home. You may have another child that is 24 and living out of home, but you may have a child that's, let's call it 20.
That's
we can call it child. Okay, sure. Right.
Yeah.
Under the age of 25, still living at home, still classified as a dependent on the deceased. And the superannuation fund would be well within their rights to consider giving the superannuation just to one of those children, right? The one that they consider the dependent. But there is an imbalance technically over your overall estate because your will may say, I want everything divided equally between my kids.
But
then you don't have anything you don't have a binding death benefit nomination, and your will isn't binding on your superannuation fund. And so they can say, well, the will says that everything has to be divided equally. And the superannuation fund will simply say, that's fine. And I can appreciate that's the information that you're giving me, but that isn't actually binding on me. So they
can give it to the third child, and then they can fight it out in the wills because that's uneven. And so the will side will be.
Well, that's right. But essentially, is there really an issue there? Because yes, there is a bit of an imbalance there. Well, not a bit. There is an imbalance there. But the actual estate has been divided as per the will.
Yeah.
And
so you just got to think about super as its own little thing that's hanging around that corner that everybody has, and you need to do something about it.
Correct.
Yeah.
That's right. And your superannuation also, it's important to note that depending whether you have a self-managed super fund or you have a retail fund or an industry fund, chances are it'll probably have some insurances attached to it as well.
Yes.
So your actual death benefit may not just be what's in your superannuation fund, but it's also the insurance payouts on top of that, which can
be quite big.
Can
be millions. Yeah. There's one particular scenario that we've run into the past with some of our members, and it's there'll be like the single person who has a superannuation, and before they get partnered up or before they have children. I think from the superannuation side, they always say the defining death benefit needs to be a spouse or a dependent or someone below them as a child. What happens in that? Is there any way to overcome that issue to pass it on to a parent, or does it have to go through your estate before it then passed on to your parents, for instance?
So that question is quite technical in a sense, like how long is a piece of string? So there is more than one way to skin a cat for that. But are we talking about someone that's newly married? And
no, someone who is just completely single.
Yep.
Bachelor, bachelorette, have no dependents, have no partners, and the only people they have in their family are their parents.
Yeah, there would be no issue then gifting your superannuation to your parents. No problems whatsoever.
Okay. And I think because some of the things that we have seen or feedback that we have had is that some supers don't actually allow you to put a parent in there.
In respect of that, you would probably have to have a look at the superannuation fund and what it says in their trust deed in respect of how it controls things, right? But generally, the larger sense there should be really no issue in providing that to a parent. But I think it also depends on the age as well of the member and the age of the parent after that as well. But if you have no spouse and you have no dependents, then
it defaults on your parents anyway. Yeah,
because just logically thinking, your estate would probably, even if they paid it into your estate, so they paid it, they didn't pay it to a person, they paid it to your estate. Depending on how that gets divided up, I would probably suggest that most of your estate's probably going to go to your parents anyways.
Yeah.
Right. But that's it may not. It may not. The real issue with all of that is the tax consequence for that. Right. And getting proper tax advice to say, okay, well, if it actually does get paid out to my parents, like what is the tax ramification on that? Right. Yeah. Because that can be anywhere between 17.5% to 32.5%. Again, it just goes down to planning and stress testing. So the client comes in and says, I have no spouse, I have no children. My major asset is my superannuation. I don't have any property, etc. Blah, blah, blah. As an estate planning solicitor, my job is to say, okay, what would you like to happen with your superannuation? I want this. Okay, what would that look like? Is there a way of is there anyone else that you would like to gift it to? And if so, what would it look like? Or is there a way of avoiding this tax somehow? Right? Do we pay into the state and put it into a super proceeds trust, for instance, right?
Yeah. So there's structures that can overcome certain things.
Correct.
And if you don't structure it right, you're at risk for either tax or complications.
Correct.
Or, yeah. Okay. All right. I think that's a very, very comprehensive. I mean, I'm sure there's a lot more things in there.
Oh yeah, there is.
Yeah.
Like I don't think we actually touched on incapacity documents at all.
We
then.
haven't. But I think that should be a great topic for the next episode because we as medical doctors, we come across that quite often, and it's not just good for our own personal sort of circumstance. It could be also good professionally to understand those things.
Yeah, that's right. And so
looking forward to having that discussion.
And look, thank you for having me, and it's been a pleasure.
Wonderful. This podcast is for educational and entertainment purposes only. The information and opinions shared are not intended as personal financial advice. The content presented should not be relied upon for making financial investment or other decisions. Listeners are strongly encouraged to seek the advice of qualified financial or legal professionals before making any financial decisions. While we aim to provide valuable and accurate information, we make no guarantees regarding the completeness or accuracy of the content. Any reliance on the information provided is done at your own risk.